Morning, Mr. Smith. Let me just remind you that you have 15 minutes. When the yellow light begins to flash, you have 1 minute left. When the red light begins to flash, unless you are in the middle of answering a question, please stop.
No. Okay.
Thank you. Good morning.
Good morning. May it please the Court. My name is James Smith. I'm the plaintiff in this matter. I tried to structure the small amount of information I want to get across this morning in terms of some questions and what I hope are good answers to those questions. The first question is, why did I come to court August 15th, 2003? I already had custody, easily 70% custody. Our daughter was happy and thriving. I was paying our daughter's tuition and usual costs of having a kid.
Excuse me a minute. What does your corporation do?
It does software used by Wall Street firms.
Software what?
Software that's used for risk assessment and calculations by Wall Street firms.
Okay, what are the deciding factors on how much money you can take from your company and how much you can't take?
Well, it's been run by a typical tech business, which is you're not pushing out dividends. You're reinvesting the money and saving it for the down cycles, which are often significant.
Is there any particular debt obligation that you were saving this money for?
There are service obligations to customers from debt in the company.
But was there any particular obligation that you could point to that you had to save the company's money for in the next year or two?
Well, yeah, you enter into contracts, which are service contracts, and you need to deliver on those contracts throughout the year. So software companies to annual renewing contracts.
Every year.
It's done by the tiny board that may.
W-2 wages, and then there are, if the company is able to do so, then there are dividends, correct?
You have salaries which are designed to be at market for whatever job is being done. When the company is larger, the job can be a little larger if one's running a large staff. When it's smaller, the senior people tend to be doing tasks, specific tasks. And so dividends are passed through as a way of paying federal tax liability. So each shareholder gets the amounts based on their respective share of the company.
But what about money over what you need?
Let's see. I mean, I think there's been very few exceptions where any money has gone out that has not been for grow the company and to survive the down periods.
Take out $250,000 in a year.
That's
Sure. You own 65%, and then a second person owns what?
About a third.
And what if there's a disagreement
On
takeout this year?
well, I think there are good controls in both directions. The other key shareholder is kind of does all the software. I do more the business side, and so there are kind of mutual reciprocal dependencies in the business.
But that doesn't answer my question. Suppose you say to this other person, I want to take out $250,000, and he says no. Then what happens?
Well, I think in a business like that, where you've got mission-critical people, they can step away. Or they could file
Or you could say, let's have a vote.
Yeah, but I think that's kind of a, I mean, there are clear fiduciary duties to an minority shareholder. You can't kind of just use the company like that as a personal trust fund, assuming it has money to take out.
Was there testimony at trial that presented a legitimate corporate purpose for the retention of this money?
Well, I guess there was in the sense that in the years leading up to trial, there were really severe losses that had been coming up at .com period, and.
But was there testimony about this at trial?
There was testimony that there were losses, which of course the company would have been bankrupt to the extent that it had no funds to fund those losses.
And was there testimony did the testimony specify that money was retained in order to prevent a catastrophic business event in the event that we didn't retain this money?
The testimony on this issue was extremely short at trial. It was minutes, so it really wasn't the main topic of the case, in fact.
Well, what was the testimony
on the
about the reason for the retention?
To keep the business alive. I mean, that was these are operating funds.
What was the testimony? I didn't say keep the business alive.
Yeah, to survive 5 down periods. I mean, I think is the way
But was there testimony as to why certain amounts had been determined?
No, in terms of amounts of,
The amount of money that was retained. How was the figure $250,000 determined?
in what context?
To retain the money for.
How? I mean, tech businesses normally do retain. I mean,
Yeah, but what was the explanation for selecting that particular amount?
I'm not sure that was a specific amount retained, actually, but
Well, whatever the specific amount was, what was the explanation for retaining the specific amount?
that is part of the company. And there really wasn't a lot of testimony on that issue. The case was really 95% about something else. So that was kind of a tiny little bit.
If we think that it's an important issue here, how much money you can take out of the company.
I think it's important, yeah.
Excuse me, do you think that we should send it back for the taking of evidence on that issue because there wasn't sufficient evidence?
Perhaps.
Presented?
I don't know. I think in general, most businesses like that, tech businesses, which I know, are quite different from, let's say, a family-owned restaurant. In a family-owned restaurant,
Well, that's all very interesting, but
Yeah.
if that wasn't before the judge, we can't do very much about it. So that's why I'm saying, do you feel that if we believe this is an important issue, it should go back for some of that evidence?
I think, I don't know the procedure, so my view is that certainly more evidence would probably provide more insight on that issue.
Why didn't you spend more time presenting evidence justifying the decision, the corporate decision to retain the money that was retained?
Because the case was limited and it was really very, very much about something else. And this was a last-minute thing. In my own testimony, it was done in minutes, and I got examined by the other side on it. I think there was some redirect, and it was done. It wasn't what the case was about.
Did you think it was not important?
I wasn't driving the questions. I mean, I think we got in what was needed to be gotten in. That, hey, this is not money. The profits don't come back to the shareholder. What comes back is money to fund tax liability.
I take it became an issue when the judge issued her order, and there was
yeah.
there were subsequent filings on this point.
Yeah, I think that's true. Sure. I mean,
When it became apparent that she was going to essentially attribute 65% of the retained earnings to you as sources of money available to pay support.
yes, which, without regard apparently to the fact there were prior year losses, which effectively washed
Right.
with, washed with the period of income. So if you take a longer time period, you get a sine curve, the losses, the profits, of that in evidence, it pretty much wound up at zero. And I think it was maybe worse than zero if I'd actually had a salary in those years when it was underwater. That's Wall Street facing business. The last downturn was after 9/11. It went way down, and we are presently in, I guess it's not in evidence, but maybe judicial notice can be taken the fact that we have something similar, perhaps a bit worse going on right now.
Well, I see, and you can always ask that this support order be modified in light of the fact that you don't have access to those kinds of dollars anymore, for example. You understand that?
Yeah, I don't know the details on that.
Okay.
If I could continue. So why did I come to court? 5 reasons. And I'm not a person who likes court, so maybe it took 5 reasons. Reason number 1, that our daughter was about to be taken out of state, where she'd be put in proximity to a maternal uncle who in the past had played a variety of games with her. In your Exhibit 23 is the tail game, where he would put a foam pool snake in the little girl's underwear. And he admitted to jail inventing that game. Okay. Game number 2, if I could some more, called Naked Run. Naked Run, he would catch our daughter, spread eagle, naked over his head and face, running repeatedly at the adult. There was some testimony about how that worked. The mother's testimony was clear. She described the mechanics of that. Child runs at the adult.
Well, let me
the
interrupt
momentum.
you. Did the judge find that game was misbehavior?
She said the game shouldn't happen. I don't think there was.
Did she? So you quarrel with the judge's failure to conclude that was evidence of some improper.
I think the issue is not so much proper or improper, but what does it predict in terms of dangerousness to the child?
So you think the judge should have concluded that was dangerous
Right.
The judge didn't reach that conclusion.
That's correct.
And
Well,
so,
dangerous enough to say, no, it shouldn't be happening, I guess. That conclusion is clear.
Yeah, I thought she found it was inappropriate.
Inappropriate, and that's, an adjective. I don't know what that means. But in terms of translating that, plus the next, the other games, TikTok, where he would tip them by like a clock, wasn't sure if they were naked or not. In Naked Run, he thinks he may have invented that game. And I should note, back in the tail game, our daughter reported being given a tail and not being able to walk with the tail in her, being given a tail by Uncle Joe. Another activity, driving the car with the girl sitting on his lap. That was worrisome, more so by the context. It's not a good thing to do, but against the backdrop of those other games, it was particularly more worrisome to me. Then we had something turn up in late 2002 in our daughter's drawings, the evil villain drawing. That was unsettling, but but our daughter wouldn't speak about it. Then what I label the Playboy-esque photo, there's debate about did the kids have lipstick or makeup on, but there's no debating they're in Uncle Joe's bedding in this picture. There's no debating that my daughter has a necklace on. There's no debating that they're both being covered by a single garment from the waist down, and that's in our daughter's bathrobe. Now that's reason one why I went to court. Reason number two for going to court was that several weeks leading up to that, the mother made it clear to me there was no reason in her mind why our daughter shouldn't be exposed to the uncle. Reason three, there were clear signs building up, and the mother may be planning to leave town. Reason four, there's a midnight arbitration or midnight mediation with David Hoffman from the Hill and Barlow, in which the mother's own father, who was then the chairman and CEO of the largest law firm in Florida, was clearly gearing up for a fight. They said to the mediator they had no idea why I didn't want our daughter on that trip. But as was later evidenced, they knew exactly why. Okay, so I'm thinking, oh gosh. The mother denied that she had a second plan to maybe instead go to Block Island that weekend, another destination out of state. Okay. Reason number five. The mediator's decision was protective in some sense. One of the designated protectors was the maternal grandmother, who under the final order under this trial is not permitted to be alone with our daughter. So late minute decision, he tried his best. I think he did a good job, but I was concerned about that as well. Now, my next question I framed was, what happened to the GL investigation of the Uncle Joe issue? Well, the GL investigation of the Uncle Joe issue was an anti-investigation. If you've ever seen that movie, the La Femme Nikita, it was like they brought in the cleaner, really. The GL actually threatened to reduce my custody if I pursued getting any more information or anything about the Uncle Joe issue. She also waited 3 years to go ahead and ask our daughter any questions about this stuff. And when she did, she asked the questions in such a way that they were designed to get a zero information response. So, for example, she asked our daughter if she played the games which her father wouldn't like. This is 3 years after the August 15 court appearance. What the GL did do is create employment for 6 mental health professionals in addition to herself and her colleague, and that included 2 of her friends and 2 parenting coaches, which may have been on a pretty short list due to that profession being a specialized profession. She threatened that if either parent didn't comply with the hiring of all those folks, that she would recommend reducing their custody. And she did an awful lot of fact-tilling, fact-omitting, fact-changing, fact-inventing, and fact-erasing. Why that occurred, I don't know. Next question, why did the judge refuse to allow the plaintiff, myself, to sit next to counsel, take any notes throughout the trial, review or read any documents or prepare any documents, or have any communication between myself and counsel during the active phase of trial? I don't know the answer to that either. I also don't know why it took 7 months to rule on post-trial motions that were necessary to pursue an appeal.
Mr. Smith, I know the time goes extraordinarily quickly. The one thing I want to assure you is that the justices will read all of the submissions, and your time is up.
Thank you.
Thank you, Mr. Smith. Mr. Pulaki?
Did you, were you representing your client below?
Yes, I did, Your Honor.
Yeah. Why wasn't more evidence put in on the subchapter S structure and how someone takes money out of such a corporation and what the money was for here?
The evidence in this case, why wasn't more evidence put in? Because no more evidence was necessary. The testimony was that Mr. Smith was a 65% owner of a subchapter S corporation, that he owned a controlling interest, that as such he had the authority to make decisions about whether that income would be distributed.
Mr. Pulaki, I understand your point of view, but everybody knows how subchapter S corporations work. They are for tax reasons, not to have double taxation. It is absolutely pro forma that amounts that are reflected as, quote, income, unquote, appropriately on a federal tax form are not necessarily income for purposes of daily living expense. You may be a 65% shareholder, but its duties, whatever it was, $92,000.
Burden of proof, and if I can study, to set forth all income from whatever source at the temporary order stage. It is the basis on which the court enters temporary orders. It is filed throughout the trial, whenever, throughout the pretrial proceedings, whenever there is an issue relating to finances. It is filed at the time of trial. It is signed under pains and penalties.
I understand that, but
in this case, Mr. Smith filed a financial statement and simply referenced in the footnote that the corporation from time to time makes money, and if you look at the proceedings in this case, we tried to get these documents. I don't know why they weren't produced at trial.
Didn't you?
Excuse me?
Didn't you get the tax returns?
I never did get the tax returns. No, I didn't.
of the figure of the income from the subchapter S corporation.
Mr. Smith testified to that. Mr. Smith testified to a range of $300,000 to $400,000 in determining the amount of income that the judge would attribute to him. She took the low range of his estimate. She took 65% of $300,000 and added that to his W-2
Mr.
wages.
Pulaki, I mean, a corporation, was there any, did you question Mr. Smith about the profit and loss of the subchapter S corporation?
He testified that the profit was $300,000 to $400,000. He testified that the profit the previous year was over $100,000. When one of the justices here was inquiring as to why the money was not distributed, which he claims, there was really no testimony on that at trial, by the way, he testified that the reason he wanted to do it was to grow the company.
That's very common in a subchapter S corporation.
I agree it is, but it seems to me that once the amount of income that's available to a obligor, in this case the father, once that amount is put on the table, it becomes his burden to establish legitimate reasons, credible, legitimate reasons.
And what's wrong with the grow of the business as a legitimate reason?
He never testified to that at trial. There was no testimony about that at trial. And I would point out to the court that this is a trial that went over a period of 7 days.
I understand.
Tried 2 days a week. He completed his testimony on the 4th day. He had an entire month to call in an accountant, to prepare returns which were, from a factual standpoint, under the Internal Revenue Code, due in March of 2006 for calendar year 2005. He never produced them. He could have produced general ledgers. He could have done all sorts of things. He did nothing. When he filed a motion for a new trial, he didn't introduce tax returns. He didn't attempt to put in general ledgers. And the statement that he made in the motion for a new trial is precisely the statement that he makes here.
Well, you said
that he
once,
wanted a cushion.
You said once that he wanted to grow the corporation, and then I thought in response to the Chief Justice's question, you said he never testified he wanted to.
He didn't testify.
So when did he say he wanted to grow the corporation?
He never testified in response to one of your questions.
Okay.
It's no part of the record, Judge.
So what standard are you asking us to adopt? Are you basically saying that a judge may consider the S income to be as if it had been distributed unless the shareholder of the corporation persuades the court that it should be treated differently? Is that basically the standard that you're asking us to?
That's not what I'm saying.
Okay.
What are you saying?
What are you saying?
I'm saying that once the level of income is established,
No. Just answer Justice Gantz's question. We've got a subchapter S corporation, right?
yes,
And income flows through, and his question was, it's then what happens?
if the income flows through, there's not a problem.
Well, the income
Because-
always flows through.
Well,
That is the tax
I
structure.
understand. The income flows through. The question is how much of that income is distributed.
Yes, correct.
Right. And in this case, on these...
And he claimed that 92,000 of it was distributed, except, that is to say, it was paid to him in compensation, and, which is not at all unusual because of the unusual,
No.
there's a distribution for payment of taxes. That is not at all unusual. Would you agree?
I would agree that is not at all unusual.
Correct.
But there was other money available for distribution.
You don't know that.
Well, no, and we don't know that it wasn't. And I say that it was Mr. Smith's burden, once the evidence was put in, as to the amount of income that the corporation made, that he was the controlling shareholder, that he was entitled to 65% of that income.
Mr.
to
Pulaki,
put
which case has said that the burden is on the employee of a subchapter S corporation?
The case Parnell versus Parnell, 64 Arkansas App, 262. Merrill versus Merrill.
You're talking about out-of-state cases
Yes, there's no in-court case on that.
for determining child support.
Yes, for determining child support. Can I commend to the court, please, an article that was somehow overlooked in our initial submission? It's very short. It's entitled "Corporation or Partnership Retained Earnings as Income Under Child Support Guidelines." It's contained at number 14, number 11, Divorce Litigation, 205.
Have you given a copy of that to Mr. Smith?
I have a marked copy, and I'll delighted to leave that with the court, or I can send up a clean copy.
I'm more concerned that you give it to Mr. Smith.
Okay, I will, Your Honor.
Thank you.
Yes.
But I still don't know what standard you're asking us to employ in general. I mean, what should be the standard that the court should have employed in this case?
The standard that I would ask the court to employ is that once that there is a determination, whether in the case of a majority shareholder who has control over the distribution of profit, and there are profits, that the burden shifts to the employee shareholder, in this case Mr. Smith, to establish why the funds were not distributed.
Okay, so basically you're saying then that the court should presume that 0.65 of the profits of that corporation should be treated as his income unless he persuades the court that it should be treated differently. That's
Yes,
the standard which you're asking us
that's
to
what I'm
adopt.
saying. And I'm also saying in this case there was no effort made to persuade the court. No effort made, no testimony with regard to reasons why that income was not distributed.
I don't know of any case where there is a presumption that whatever the percentage of the employee shareholder in a subchapter S corporation, that those amounts are available to him for his personal use.
You're premising this on being a majority shareholder, aren't you?
I'm sorry, Your Honor?
You are premising what you're saying on the fact that he is a majority
Controlling
shareholder and therefore
65% owner, yes.
can presumably has some control over how the money can get distributed.
And he never argued anything to the contrary at trial. And as a matter of fact, in his post-trial submissions and his motion for a new trial, He never argued in his motion for a new trial that he didn't have control. And presumption, I think, is a little too strong a word, Your Honor. I'm saying simply that the burden of proof shifts once the level of income is established. And that
You mean
Mr.
once it's established that he is a majority shareholder?
Yes, that's right. That the burden at that point shifts. And the article which I cited to the court deals specifically with differences between majority shareholders and minority shareholders, where in the case of minority shareholders, the burden...
Assuming we were to agree with you, Mr. Palaki, assuming we were to agree with you, that was not an existing burden that Massachusetts has recognized. That's why I was asking you for Massachusetts cases.
It's not clear on the probate court who bears that burden. This is an issue that's constant, and I will acknowledge that the income is not always the best indicator of what funds
If we were to establish such a shift of burden of proof, would it make sense, as Justice Cowen suggested, to send back to take testimony on this?
I don't think so. I think Mr. Smith had an adequate opportunity at trial.
But he didn't know he had a burden.
I'm sorry?
He didn't know that there was a burden shift.
He certainly knew that the money was out there. He certainly, I think, was in a position and should have known enough to offer an explanation as to why the money was not distributed.
Because at least I could say that as a general matter, if the question is what have you received from the company, and the answer to that is a truthful $92,000.
But I'm not even sure that's the testimony on the record. Testimony on the record is that he had $92,000 in income, and with $300,000 to $400,000 of other income, 65% of which he was entitled to.
Did you make a request, a specific documentary request for the corporate tax return?
The K-1?
Yes, and document requests prior to trial. We never received them. We
Okay.
were always...
Did you pursue contempt or a motion to compel?
We didn't.
Could I ask you a question? I'm not a probate lawyer, but forget sub-S corporations.
Right.
An asset is listed on a husband's, in this case, financial statement. Some asset that's got to be valued, and there may be some issue as to how much access he has to it. Is that, as a general matter, I mean, whether it's a 401k or a pension or whatever, does the burden, once it's listed there, does the burden fall upon the holder of it to show, well, this really isn't available, or is it in my example, is it the wife's burden to show that it is?
I'm not sure. I know there was a case called Kurtz versus Kurtz. I think it's been reversed. It's an appeals court case, probably going back 15 years, which stood for the proposition that it was the burden of the party who challenged the value to prove it. I think there's a subsequent case to that. I would point out in this case that the testimony with respect to LMT, I don't think was particularly credible, and I will finish, because Mr. Smith consistently listed loans payable and loans receivable in a footnote, but never referenced them in any amounts in his financial statement, and stated in at least 2 of his 3 financial statements that his expenses were being funded by loan repayments from the corporation. And the amount of the loan receivable due to him from the corporation was not reflected. I'm sorry I'm out of time. Thank you very much.
Thank you, Mr. Parkin.
Can I say one more? Never mind.
As I said to Mr. Smith, I can assure